Hello, everyone, and thank you for attending today's webinar, Using Affiliates in Advertising, Pitfalls and Safeguards. I'm Shaheen Rothermel, and I'm here with my colleague, Ari Rothman. Before we begin, we wanted to cover a few housekeeping items. At the bottom of your screen are multiple application widgets you can use. All of the widgets are resizable and movable, so feel free to move them around to get the most out of your desktop space. If you have any questions during the webcast, you can submit them through the Q&A widget. We'll try to answer these during the webcast, but if a fuller answer is needed or if we run out of time, your question will be answered later via email. Please know that we will capture all questions. The webcast is being streamed through your computer, so there is no dial-in number. For the best audio quality, please make sure your computer speakers or headset are turned on and the volume is up so you can hear the presenters. If your slides are behind, try pushing F5 on your keyboard and that'll refresh the page. And you can find additional answers to some common technical questions located in the Help widget at the bottom of your screen. So without any further ado, we'll get right into it. So today, this is what we're going to talk about. We are first going to give an introduction into affiliate marketing. We'll talk about some of the risk areas. And then we'll go into vetting and onboarding affiliates, how you should monitor your affiliates, affiliate agreements, and we'll get into some channel-specific considerations. So affiliate marketing is a relationship in which an advertiser or merchant, somebody who owns an offer, a brand, pays another entity to generate traffic or sales that is driven by a third party. The third parties are known as affiliates or publishers, and that entity that sits between is what we'll call the network for the purpose of this conversation. And using affiliate marketing allows advertisers to expand their reach in their marketing and to grow sales by having more and more entities disseminate their promotions. To do that, the affiliate first either obtains the ad from the advertiser or from the network, or it creates the ad, and then it disseminates it. The consumer will visit the affiliate's website or view the affiliate's advertisement or interact with that advertisement depending on how it's disseminated and what channel. They'll then click on the affiliate ad or the link or the other call to action, or they'll make a purchase. The sale or the action is then measured somehow, and it's linked to the specific affiliate or publisher that generated the action or the sale. After that, the advertiser or the merchant pays the network, and then the network pays the affiliate or publisher some portion of the amount. We thought this would be useful to provide to everybody. This is an infographic or graphic that the FTC has on its website. So this will give you a little bit of insight into what the FTC thinks about affiliate marketing. So, and this is consumer oriented. So you see an ad online and it tells you then who's behind it. You have the merchants or the advertisers who own and sell products, the affiliate marketers, networks who connect the merchants to affiliate marketers, the various ways that affiliate marketers will produce the product, promote the products. And then a consumer clicks on an ad or makes a purchase, then everyone gets paid. And then the bottom part here on the right-hand side of the screen is really the most important for our purposes, which is what the FTC says to consumers about what happens when they click on the ad, which is that somebody's getting paid, you're getting tracked, and then they raise this question as to whether or not the ad is truthful. So these are some issues that are underlying affiliate marketing generally, and some of the risks that apply to advertisers are these issues, and we'll go into those in a few more depth.
So using affiliates comes with risk, and some of that is identified by the Federal Trade Commission and its position on affiliate marketing. And one of the things we hear a lot is from the advertiser's perspective, when they get an inquiry from the Federal Trade Commission or State Attorney General, or even a private plaintiff for that matter, about an affiliate's ad, the common response is, well, we didn't know who the affiliate was, much less what the affiliate was marketing or how it was marketing or what it was saying. And the Federal Trade Commission and others take the position that that doesn't matter, that the advertisers are responsible for the advertising that the affiliates conduct on their behalf, whether the advertisers know about it or not. We put some quotes from the FTC in the presentation to sort of validate the FTC's position on it. Your company is ultimately responsible for what others do on your behalf, and delegating part of your promotional program to an outside entity doesn't relieve you of responsibility under the FTC Act. So that's definitely a risk that is worth highlighting in the use of affiliate marketing. So then in terms of the FTC's jurisdiction, the FTC has broad jurisdiction over anyone who participates in the creation or dissemination of advertising, or anyone who directly or indirectly participates in presenting a commercial message. That's basically anybody up and down the chain. In that prior depiction that Shaheen showed you from the Federal Trade Commission, it can include everybody there. So the advertisers, the affiliate networks, the publishers, the agencies, the endorsers. Anybody up and down the chain, the Federal Trade Commission can look at and has in the past. So that leads to the risks here. Typically, advertisers cannot control or even know about the affiliates, and that's true in some circumstances. I mean, if you're an advertiser and you can have strict controls around, you tell your network, these are the only creatives that you can use to promote our offer, that's one way of maintaining control. But the whole purpose sometimes of hiring an affiliate network or a downstream affiliate is to tap into their expertise on what works in terms of generating traffic, because the advertiser might not have insight into that. And when that happens, you sort of lost control and knowledge about it, and that's where things can go sideways. Some of it is perfectly legitimate, others aren't. And I'm sure we have many examples that we can share with you where we've seen what we refer to as rogue affiliates do things that they shouldn't be doing. The advertiser doesn't even know that it's happening. Financial incentive is obviously something, especially on a CPA or cost per acquisition or cost per action campaign. The higher that CPA is, the more careful you should look at that, because that's going to incentivize the publishers to convert, perhaps, maybe, more aggressively than they otherwise would. And then, of course, there's the tracking and privacy issues, too, that affiliates undertake. After they get somebody that does that initial click, it's not uncommon for the affiliate to market other offers to them. So what about the obligations, Shaheen?
Sure. So the FTC has been increasingly going, up and down the chain and looking at what various people are doing when they're looking at promotions and they're scrutinizing it. So we're seeing a bigger and bigger trend of the FTC going after advertisers, looking at affiliates and what they're doing. So it's becoming increasingly important for advertisers to have programs in place when they're onboarding their affiliates, so vetting your affiliates or your networks on the front end. We put training in here, but it's about having appropriate policies as well and monitoring members of the network. The program should be tailored to your business and what you're doing, the risk level of the vertical that you're in, how the various promotions are being disseminated. So certain marketing channels are more risky than others. And the other thing that we'll say too is that the FTC has come out with a lot of consent decrees recently in which it imposes obligations upon advertisers and what they need to do vis-a-vis their affiliates. And we'll talk about that as we're going through these things, but both Ari and I, we've had these conversations with clients, and a lot of times the response from clients are, this is just not feasible. We can't do this. And we'll talk about that with specific circumstances, but these are all things that the FTC is expecting. So here's an overview of the affiliate management process, onboarding and diligence, ensuring that your affiliates are aware of the latest FTC regulations, including the regulations that are channel specific, getting the appropriate contractual provisions so that if anything goes awry, that you have something in place to take care of that you're monitoring and auditing your affiliates consistently, and that when you see something wrong, that you take corrective action, and that you're documenting the proceedings, that you're documenting everything you're doing. We can't emphasize enough that as attorneys, when we get a demand letter, when something happens, we get something from the AG or the FTC, having that documentation goes incredibly far in helping us to defend the actions and showing that the advertiser did act appropriately under the circumstances. So when you're onboarding an affiliate or network, what kind of information do you have to collect? And we've included some information here. And from both a practical perspective and from what the FTC expects, it makes sense that you get information about the people you're working with. If it's a natural person, you get their first and last name. You get contact information via email and a physical address. Hopefully, it's not just something that's a postal box, a PO box, but somewhere where you can actually reach the person, the business name and contact information. And I'm actually going to read off some things that the FTC just recently required in a settlement so that you can sort of see the requirements. I understand that these are pretty arduous. So in a recent consent decree, the FTC required that the advertiser, before it onboarded any affiliate or network, that for natural people, it obtained the first and last name, physical address, country, telephone number, email address, and complete bank account information as to where payments would be made for a natural person. For business entities, the affiliate or affiliate network's name, any and all names under which it does business, so all of the DBAs, the states of incorporation, the registered agent, and contact information, full name, physical address, telephone number, email address, for at least one natural person who owns, manages, or controls the affiliate or network. And what the FTC says is that if you don't have direct connection into the affiliates, so if it's not a direct relationship between you and a publisher, if you're working through a network, that you have to have provisions in place with your contract to require the network to obtain and maintain those identifying information from those affiliates. And that's a pretty high bar to do, but we'd admonish advertisers to ensure that they do have at least some of this information, that not just in the case of the FTC challenging your advertising that was disseminated through a publisher, but also if something goes wrong where you need to actually get redress through litigation from an affiliate or a publisher, that you've gathered this information so that you're not just left with somebody who you can't receive that redress from. Or do you want to talk about this?
Sure. So, asking questions seems like the natural thing to do when you're vetting and onboarding your affiliate in your networks. Has the affiliate been involved or the subject of government investigation or inquiry or litigation? Has the affiliate ever had an advertiser cancel or terminate the affiliate due to excessive chargebacks? There's various ways to track that. And if you're not doing that, if you're not watching, if you can't link a chargeback to a network and then the network's downstream affiliate, at least by a sub-ID number, that's something that we recommend doing, because sometimes it's not the network that is messing up. It's one or two or five of its downstream affiliates, and you should be able to track those by sub-IDs. Ask about traffic, sources, audience, and promotions, and then do your own research. Now, we recognize that a lot of networks take the position that the identity of their affiliates is confidential, the theory being that the advertiser could go around the network and interact directly with the affiliate. And maybe that's true, maybe it isn't, but what you can do to get around that concern here is, again, going back to the previous slide, we don't need to go back to it, but contractually require this information. So have the affiliate network say, we're not going to use any affiliates that have been involved in an FTC litigation. We're not going to use an affiliate for your campaign that has driven excessive chargebacks for a campaign like this in the past. And then the traffic sources, they're never going to show you exactly what the traffic sources look like, but you could say, look, is it native advertising? Is it email? And you can specify that in an insertion order as well. So there are ways to do all the things that are here and that the FTC is requiring, while also getting around the affiliate network's position that they don't want to disclose who their affiliates are or what the initial advertising is in some cases. And so monitoring, so this is, again, the FTC's position, and this is a quote: "It's unrealistic to expect you to be aware of every single statement made by a member of your network, but it's up to you to make a reasonable effort to know what participants in your network are saying." And so that's sort of, it's a tad gray. I mean, they're acknowledging that you can't know everything that's going on, but you do have to make some reasonable efforts. What are reasonable efforts? Case-by-case circumstance. And some of the things that we're talking about doing and having an onboarding process that's documented in real time that you could show to the FTC that says, look, when all of this was going down, this is what our KYC process was, our investigation process was, and maybe somebody slipped through the crack, maybe it didn't, but it's better than not having anything, because having nothing is going to be hard to explain.
That's right. And Ari raises a good point. What the FTC considers reasonable might not necessarily be what advertisers and other people who are actually on the ground trying to promote their products and just run a business might think are reasonable. So the first thing is really that you have to require your affiliates to comply with the law and applicable regulations. So the sort of overarching principle of this is that you can't do something indirectly through an affiliate that you as an advertiser or brand wouldn't be able to do directly. So all of your advertising must be truthful and non-misleading. There has to be appropriate disclosures, and those disclosures might change if you're in the financial industry. There are specific disclosures that must be made, and if you're using a publisher, if you're using a lead generator, you need to make sure that the required disclosures are on those pages. If you're using, let's say, email-specific marketing, then you have to ensure that you're complying with all of the regulations pertaining to that. Another big point that we could spend a long time on is data privacy and security. And this really this runs the gamut. No matter what you're doing, what type of product you're promoting, you have to make sure that you're complying with the appropriate regulations and laws concerning privacy and security. So making sure that your affiliates are providing appropriate notice about the information, what's being collected, how is it being shared. Is the affiliate telling consumers the accurate way of the fact that they're taking their information and sharing it with a third party, they're sharing it with you. Depending on the channel, making sure that the security measures being held by the affiliate are appropriate. If you're gathering certain types of information, you have your affiliates gathering certain types of information. So there's data that's very sensitive, geolocation data, financial information, of course, and information about children. Those are all, highly regulated, highly scrutinized types of data that you need to be really careful with if you're collecting it, what's being told to consumers, and how that data is being stored. And then, we really can't reiterate enough the documenting all compliance activities. So, when you're requiring affiliates to comply with the law in your contracts or in other types of policies and written documents, that you have those written documents, that you're keeping them somewhere, that you're not just deleting them every 90 days in your Outlook, so that if, heaven forbid, something happens, that we have those documents.
So continuing on with the monitoring affiliates, that's what we recommend, is establishing, implementing, and maintaining a system to do it. So don't just write something down that says you're going to do it. You actually have to implement it, show that you implement it, and maintain it, and show that you maintain it. The next bullet sort of has the baseline requirements that we would recommend, which would be monitoring and reviewing the media if you can do it, and taking remedial action when you find violations. And again, going back to the piece we talked about on chargebacks, like that can be, but not always is, a way to know something is going on. And there's various ways you can detect that. There's lots of software companies and other sophisticated ways you can figure out what that problem is, but get on top of it. And when you see it, do something about it.
That's right. So here's something that the FTC has required in settlements. And this is a question we get a lot. So you're an advertiser, you have ad copy, you have creative that you want disseminated. How do you make sure that your affiliates are going to be disseminating the copy that you provide? They're not, they're not adding images, adding claims, revising it in any way that could affect your liability under FTC's rules and regulations concerning advertising. So in that respect, in a consent decree, the FTC required that the defendant, before an affiliate or a network disseminated advertisements on behalf of the advertiser first had to require the affiliate to provide it with copies of all materially different marketing materials. So if the affiliate or the network was changing the marketing materials that would go out, the advertiser had to obtain those, according to the FTC, the advertiser had to obtain those from the affiliates and review them before they went out, that the advertiser knew the location where the materials would appear, and then that the advertiser had to know the locations to which consumers would be directed, so a landing page or otherwise, if they clicked on a hyperlink that was disseminated by the affiliate, and the range of dates that the marketing material were going to be disseminated to consumers. So, as we said, this is pretty arduous. It's maybe what the FTC considers reasonable. Attempting to adopt practices like this really is something that we recommend, knowing what's being put out there, ensuring that you don't have rogue affiliates that are going off the reservation and providing information or disseminating claims that you wouldn't be able to make directly. So this goes to Ari's point earlier about chargebacks. Another thing too is it's not just chargebacks, although chargebacks are a really good data metric. There's also the aspect of customer complaints. It's always a good practice to monitor complaints in the first instance, and not just for the purposes of monitoring your affiliates, but also for just monitoring your own activities and ensuring that you have a satisfied customer base, obviously. And, one thing we'll say too all the time is that the easiest way to get some scrutiny from a regulator like the FTC or a class action plaintiff is by having a lot of customer complaints. So, all that's a really long way of saying that if you get complaints, if you get chargebacks, try to figure out where they're coming from. Are they coming from the same network? Is there a specific sub-ID, a specific publisher who is disseminating advertisements that could be causing these complaints or these chargebacks? And another way to do it is audit the advertising pages where your affiliates are promoting your offers, going through and checking to make sure that the ad copy that's approved or that the ad copy that's actually being disseminated is complying with the law, that there's no funny business going on. Do you want to?
Here's what sort of the back end. Terminate affiliates who do not comply with the law and your policies and procedures. It's a case-by-case basis a lot of the time, but if you see something flagrant, you should be terminating or asking the affiliate network to terminate the affiliate by sub-ID. And if you see a lot of the network's affiliates, different sub-IDs coming up with a lot of bad traffic all at the same time, you need to consider whether you've got to call up the affiliate network and start talking about disabling or terminating the network altogether. Our experience is that is rare, but it can happen, and sometimes it's warranted. Disable the affiliate's links. That way it can't convert, and that will be one way to stop the problem. Halt the processing of any payments or charges generated by the affiliate or network. The link sort of does that. Refund customers. Consider whether you've got to do that proactively or whether you wait for the chargeback to come in or the refund to come in. But our experience is if consumers receive their money back without a lot of hassle, that decreases the odds of something escalating. And that is something that we recommend that our clients do, our advertisers do whatever they need to do to de-escalate these kinds of transactions, especially in a card not present environment where the merchant processing rules are so stringent. And then document all the remedial actions. Again, we can't beat that drum hard enough. In the case of terminations, it can be very powerful evidence to show that you, before the state attorney general, the Federal Trade Commission, or a private class action plaintiff, before they ever started knocking on your door, you had terminated whatever affiliates you needed to terminate based on the activity that you saw, rather than letting it continue. That can be very helpful information for an advertiser if they're ever asked about the processes that they undertook. And so that leads to the affiliate agreements. We've actually, Shaheen and I have done a whole separate presentation on this in another context. And so we'll go somewhat quickly through this one, but this is a very important document that we recommend that is in place and is robust, and it's followed. Don't just say something in a contract and then think you'll be able to wave it around and everything will be okay. You're going to want to show that you have followed through with the things that are in this affiliate agreement. So Shaheen, why don't you go through some of the specifics? I'll just make the general comment that the tension we see in these agreements is payment terms. How long will an advertiser pay? Because the advertisers incentivized to pay it out as long as possible to see if those chargebacks come back, while the networks will say, I need to get paid in 3, 5, 7, 15 days, maybe on the outside, sometimes 30 or 60, because they need to pay their downstream affiliates. So that's a tension that's always in these agreements. But here's some other points that we think would be helpful.
Right. And another initial note, too, is that now that we're, on the agreement section, this is not something that's going to save an advertiser if the Federal Trade Commission issues a CID or if litigation is initiated. This is a way to obtain certain protections in a document that you would be able to use in your own private litigation. And it would be helpful in certain instances to be able to show, the FTC or state AG that you have these provisions in place. But it will not be a panacea. If something goes wrong, as Ari said, you can't just wave this document around and say, well, I have this agreement. So with that said, as we were talking about a little bit earlier, the creative assets, what types of creatives are being disseminated, who controls the creatives? That's something that's really important to delineate in your agreements. If I'm the advertiser and I want to ensure that people are only making, XYZ claims about my product, if they're only putting out very specified types of pictures, that should be clarified within the agreement. If an affiliate or the network wants to make changes to the creative and how they go about doing that, that needs to be clarified in the contract as well, whether or not they submit it and you agree to it, whether, what the time period is for that. So making sure that that's clearly set out in the contract is very important. Another issue, too, is, as Ari was mentioning, the question of payments. So if payments are required to the network within a very short period of time, if it's net, let's say 14 or something like this, but you as the advertiser don't have, it's going to take more than that period of time to go through and make sure that, everything is going swimmingly. You need to make sure that you have time built in to investigate the traffic. So what you'll see sometimes in form agreements is that if an advertiser doesn't contest the traffic within a certain period of time, then the right to contest that traffic is waived. So, you've paid for this traffic and the traffic might not be good traffic and you don't have anything in the agreement to help you with that. You've paid for it, you're on the hook for it, and that's that. As Ari mentioned, the chargeback cycle oftentimes is longer than the time to contest the traffic. So you've paid for traffic, you've waived the right to contest it, and a customer charges back, if you don't have protections in place or you haven't negotiated those, then you've paid for that traffic. And the sort of countervailing consideration here is that if you're working through a network, they really need provisions to protect them because they have to pay their publishers, and they don't want to end up paying their publishers for traffic that the advertisers aren't going to pay for, because advertisers are going to contest the traffic, the network has paid its publisher, and then the network is stuck holding the bag. So these are sort of considerations that go into place when you're discussing payment terms and timing. So when you have limitations, liability, disclaimers of warranties, indemnification provisions, they run the gamut in these contracts. You might have a form contract that you're looking at where the advertiser is indemnifying the network and its publishers for everything. That you have to look at these to see who is the one really holding the bag, who is running the risk. Are you disclaiming all warranties with regard to your creative and the type of products that you're selling? Is the network disclaiming all warranties concerning the creative that its affiliates are sending out? So it's really important to look at that and really critically see who's indemnifying whom, and does it make sense for whoever is indemnifying to be the one who's doing that? Because the risk oftentimes will lie with the advertiser. The Federal Trade Commission, in the past at least, has always gone to the advertiser and challenged the advertiser because they're saying, you're the offer owner, you're the one who's selling something, you're the one who's making money from it. Nowadays, we're increasingly seeing the FTC go after affiliates. So, there is this tension as to who really is running the risk when there are violations.
hit the set off chain.
Sure. So, this is a standard term. The question of whether or not, let's say an affiliate or network breaches a contract, can the advertiser withhold payments or set off payments against whatever the damages are in connection with that breach? So that's a provision that can be used to, protect the advertiser, or can be used by a network so that the advertiser is still on the hook for payments even when there's a contested breach that's occurred.
And so another provision that is worth discussing and addressing, and which could be a little more flexibility, you could have more flexibility with, is the dispute resolution and binding arbitration provision. If there is a dispute between the advertiser and the network, the next question becomes, how and where is that dispute going to be resolved? And the first question that we generally ask is do you want to do it in open court, which is generally a public proceeding? Everything is available to the public except things which are considered trade secrets, and some jurisdictions will require you to show that trade secrecy actually exists before allowing you to file anything under seal to prevent it from public view. But court is very public. It can be very expensive, as can arbitration. Sometimes arbitration is more. But you have tools available to you, regardless of whether you're the one suing or being sued, that are not necessarily available to you in arbitration, such as discovery tools. If you need emergency relief, if you need to get an ad to stop, or you need something, if somebody's using a celebrity endorsement or an ad that they shouldn't be using, you need to get it to stop, and they won't stop voluntarily, you can go in and get a preliminary injunction. But it's very public, so you have to ask yourself, if there is a dispute, do you want the world to know that you've got this dispute with this network or not? Now, on arbitration is private. It's generally confidential. Nobody really knows it's happening except the two parties that are in dispute and whatever the arbitration firm is that's handling it. It's a lot less formal, but you pay somebody by the hour, literally. In a bigger case, multiple people and sometimes their associates by the hour to resolve the case. And there's benefits and drawbacks to it. I mean, sometimes it takes longer, sometimes it's shorter. You don't necessarily have the discovery tools. A lot of the times you have to ask the arbitrator if you can take depositions, if you can ask the other side questions, if you can get proof that you otherwise wouldn't be or only would be able to get through the court process. But the big benefit of arbitration is that it's confidential. And so that might be something you have to consider, again, on a case-by-case basis. Next question you have to ask yourself is where would that dispute be resolved? Surely if you are a U.S.-based advertiser and you're dealing with a network overseas, more often than not, if you think you're going to be the one that's going to need to enforce the agreement, you're going to want to have the forum be somewhere in the United States, either your principal place of business, if you're an LLC, wherever your members are located, if you're a corporation, your principal place of business or the state of incorporation, somewhere in the United States where you can justifiably bring in the other party and establish personal jurisdiction over that other party. And you can put language in the agreement that says, by entering into this agreement, I, as a foreign entity, agree to the jurisdiction of all of the courts in state X. And then you've got them hooked in, and they're going to have a hard time wiggling out of that. And then you have to figure out which state law applies. I mean, depending on what you think your risks are, contract law is pretty common. It's pretty ubiquitous across the board. There aren't major deviations from state to state. But if you think that there's been some sort of unfair competition that's occurred or some other tort, that can vary from state to state. And so that is something you'd want to carefully consider. And then, in terms of what jurisdiction going in terms of where, do you want to sue where you are in your own backyard, or would you rather keep it away from your neighbors and go somewhere else, maybe where the affiliate network's located? So those are all considerations that are often times breezed through in the agreement, but are important to spend at least a few minutes discussing either internally or with your lawyers about that issue. And finally, we make this point a lot. the affiliate agreements that we do in our practice, they have the same features a lot of the times as they go from agreement to agreement, but one agreement is never the same as the next. Each advertiser or network has its own risk tolerance, has what its priorities are. It has things that can and can't do, like the slides that Shaheen was going through earlier about what the FTC required. I mean, some of that stuff just isn't possible, and you're never going to be able to get anybody to sign that agreement. Other clients we have a lot of marketing power, and they can say whatever they want in their agreement, and they'll get other people to sign it. Where we see the biggest problems and the biggest disputes is when somebody cribs an advertiser agreement that they got from somebody else, changes the names. I mean, we've seen it where they change the names like 5 out of the 6 times, and then it ends up there ends up being a dispute, and the agreement actually doesn't govern what it was the parties were doing. And so, be smart about this. It's a very important document. If there's ever a business-to-business dispute, some people say there are shelf documents. I personally don't believe in those. And knock on wood, haven't had to defend any of the ones that we've drafted, but just be very careful when you do this. Don't just grab something off the shelf and hope everything will be okay.
And nobody thinks much about the agreement until it comes time to defend or enforce it.
Right. Oh, good. This is channel specific. I guess I get to keep going on email marketing. So we talked a lot about the contents of the ads in terms of not being misleading. Now, there's various laws also that talk about how the advertisements are going to be disseminated irrespective of the contents of those advertising. And one of, I guess Shaheen will talk about text messaging and so forth under the Telephone Consumer Protection Act, which is one of the most prolific statutes being litigated across the country right now. But for affiliate marketers and downstream affiliates and advertisers, we've seen over especially the last 15 years or so, a lot of email marketing disputes, especially coming out of California. And that is a law, in addition to CAN-SPAM, that is worthy of compliance. If we go to the CAN-SPAM Act, maybe Shaheen, you talk about the CAN-SPAM Act, and I'll hit up California.
Sure. So CAN-SPAM is the federal law regulating commercial messages. It's called CAN-SPAM. So it's not an opt-in statute. You don't need to have consent under the law to send emails to recipients. It requires that you identify the email as an advertising message, that you don't have false or misleading header information, that your subject lines are truthful and non-misleading, and that you have an opt-out method that needs to be honored in 10 business days, and that it includes the sender's valid physical postal address. So 2 of the points here that I'd really like to touch on are, first of all, the opt-out method. So CAN-SPAM requires that you have a way that people can opt out. It needs to be easy. It needs to be either clicking on a link or just responding to the email. And when a recipient asks to opt out, that needs to be honored within 10 business days, although I'll tell you, the sooner that can be honored, the better. When we get into affiliate marketing issues, we have advertisers who receive opt-outs. They've got a suppression list. That suppression list needs to be communicated to the networks, and those suppression lists need to be communicated to the affiliates. We can't tell you how many times we've had situations where you have a sub-affiliate who just keeps sending emails to a person who's on the recipient list or on the suppression list. And that really is bad when that recipient is somebody who's a prolific plaintiff. Ensuring that you have the sender's valid physical postal address. So the FTC regulations allow this to be a P.O. box as long as it's appropriately registered under the statute. And one of the questions that we get a lot here is, who is the sender for the purposes of the email? People ask all the time, does it need to be my address? What if there's 2 senders? Is it the affiliate's address? And this is pretty, we have plaintiffs' attorneys who talk about who is the sender all day long. As a best practice, we would say that the email needs to have the physical postal address for the advertiser. that there's a way that consumers can contact you, not having, a P.O. box just for an affiliate out there. The other thing about the CAN-SPAM Act is that, unlike the California law that Ari's going to talk about in a minute, CAN-SPAM provides a very limited right of action. So the government can enforce CAN-SPAM, and internet access providers, so access services, can enforce CAN-SPAM as well. So the normal private plaintiff, John Doe down the street, doesn't have standing to enforce CAN-SPAM, but he does have standing to enforce the California law, which Ari will talk about.
And the Federal Trade Commission, too, will often throw in CAN-SPAM violations when they have an enforcement action on the false advertising under Section 5 of the FTC Act. So it's in this, the statute has pretty severe penalties. So it's definitely worthy of keeping up to date on. And I mean, for the simple reason, on the unsubscribe list, you don't want people getting your emails who don't want them as a practical matter, because they're the ones that are most likely to screen. And if that happens and they get to the right people at the government and it happens in sufficient quantity, then you're going to have a problem. You're going to end up with a civil investigative demand, or if they're in California, if they're a California recipient, with a California Anti-Spam Act lawsuit. Now, here's the thing. I get this question all the time. If I am a company that is not in California, my affiliate network is not in California, and the downstream affiliate is not in California, can I still be sued under the California Anti-Spam Act? The answer is yes, because anybody who is a California resident that receives an unlawful email under California's Anti-Spam Act has a cause of action against anybody who was involved in that email, regardless of where those people are located. And so, since California is the most populated state in the country, odds are that if you're using an affiliate network using email as a marketing channel, they are going to reach not a small quantity of residents located in California. So we tell our clients, follow the California Anti-Spam Act. It's the most litigated statute in the country on this topic. There are other states that have laws like this that some are litigated more frequently than others. And there's a whole other presentation and compliance protocol we provide for email marketing. We'll just get the highlights here. But for purposes of this presentation, it's with 80 to 90% certainty, it's safe to say if you're complying with CAN-SPAM and the California Anti-Spam Act, you're also likely complying with all the other states as well. So like CAN-SPAM, under the California Anti-Spam Act, you can send out as much unsolicited commercial email as you want. As much unsolicited commercial email as you want. What you can't do is send out any emails that are false or misleading, materially false or misleading. Let's stay on this one, actually.
Okay.
But if you've got consent, then the penalty drops down. So on the second bullet here, it's enforced by private parties. That could be an individual residing in California or an internet service provider or the state. It's $1,000 per email or actual damages up to $1 million per incident. You can bring that number down through two ways. The first is having a due care defense. So you can implement practices and procedures designed to prevent violations of the statute that will then require the court to look at that, and the penalty will drop to up to $100 per email. So that's a pretty significant reduction. Although it's not on the bullets here, the second point is if you've got direct consent to send those emails, the plaintiff cannot seek that $1,000 per email penalty. They can only seek actual damages, which as a practical matter is basically zero. It's very hard to prove actual damages in a spam case. And so what you can do to mitigate your risk is only send out to people who have opted in, which may or may not be feasible depending on what you're doing. But I thought we would throw that in there. Under the California statute, advertisers are liable for the actions of their affiliates and third-party email vendors. It's essentially a strict liability statute as the law sits right now. Maybe the right case will come along and it'll change that, but you're responsible for what's in the emails. These are basically the three categories at a high level of what the statute prohibits. It prohibits sending an email advertisement containing a third-party domain name without the permission of a third party. So if I were to send an email that looks like it's coming from, or the domain name, the same domain is, nameyourBigRetailer.com, and it's not coming from nameyourBigRetailer.com, or I don't have permission from that retailer to use that domain name, that is a violation of the statute. Email containing falsified, misrepresented, or forged header information that might sound self-explanatory. It's been the subject of ongoing litigation for years and years. That basically means don't lie in the, don't make the email look like it's coming from somebody who it's not coming from. And there's some plaintiffs' lawyers that take it a step further and say you actually have to accurately describe who the email is coming from, and you can't have generic from names and everything else. Like everything else we're talking about, this is very campaign specific. You should take a hard look at your from names, your friendly froms, to see if those would, pass the smell test or not, and therefore pass the California Anti-Spam Act. But there are a lot of technical points too that you need to take into consideration when making that decision. And again, we're happy to discuss that offline, but that's the subject of a whole other presentation. And then the subject line also, that's also, you can't have false or misleading subject lines. So an extreme example would be where the subject line says your bank account information is contained in this email. And then you open it up and it's an ad for some sort of nutraceutical or something like that. That most likely, even though the consumer has not been misled into purchasing anything, could be viewed as a misleading subject line and subject to the $1,000 penalty. So just like the from names, we always recommend coming up with the subject lines and looking at them and say, look, does this subject line that we're talking about relate to the contents of the email? If the answer is yes, then it likely passes the statute, assuming it's not independently false or independently misleading, like offering something completely free that isn't qualified in the email, for example. That would still be problematic. But you got to have truthful subject lines. Otherwise, that's an independent violation. It only takes one of these three things to make the email subject to the $1,000 penalty.
The next area we're going to talk about is social influencers and brand ambassadors. Social media is a big channel. We could talk about this again. I mean, all these channels we could talk about for, have their own hour-long presentations on too. But I know a lot of clients like to have their brand ambassadors promote their products on various social media channels. And, as with the other things that we're talking about, it's all very channel and campaign specific. So when we say social media, there's a lot of different types of social media. It can be Facebook, it can be Instagram, it can be Twitter, it can also be YouTube, it can be Snapchat. There are just so many different media that are coming out every day. And as a result of that, maybe not every day, but there's so many different media that are being launched these days that the risk is, marketers are trying to keep up, advertisers are trying to keep up, and the FTC continually is coming up with new guidelines, new recommendations to sort of keep up with what the various social media channels are doing. So we're seeing the FTC's action. It's doing a lot of, guidance in this area for advertisers. So it's something to always keep your eye out to see what the FTC is saying about these channels and these media. So the general principle for using brand ambassadors and social media influencers is that if they're promoting your product and they're receiving something for it, or if there's a connection, a material connection, then they must disclose it. This is a regulation. Where there exists a connection between the endorser and the seller, so the advertiser, that might materially affect the weight or the credibility of the endorsement that's not expected by the viewer, then that connection needs to be disclosed. So let's break that down. If you have an influencer who's promoting your product, they have to disclose any material connection. So these are all examples of connections. We normally think of a material connection as a payment, money. That's pretty straightforward. But the FTC takes a very broad view of what is a material connection. So free product, a sweepstakes entry, anything of value. So if somebody, if an advertiser flies somebody out, for a $5,000 trip, that's going to be something of value. If there's a business or a familial relationship to the seller or the advertiser, or if there's an employee who's promoting their employer's product, That's a material connection according to the FTC. The second sort of prong of this is something that would not be expected by the viewer. And this is the sort of second wrinkle of this is, as we're seeing more and more activity by social influencers, there's just a ton of brand ambassadors. A lot of famous reality stars are becoming these brand ambassadors. The question becomes, what would a consumer really expect to, be an ad? Whenever somebody famous discusses a product on Twitter or Facebook, is that an ad? Is that something that needs to be disclosed? So the FTC's position is when it's not obvious that it's an advertisement, people should disclose that they're being paid. The FTC, what the FTC says is the easiest way to do that is just saying #ad. It's 3 characters. Question as to whether or not saying thanks is okay. Is enough, thanks to the advertiser, is that okay to disclose? Is that enough? It's content specific. What the FTC expects and what we as people who are in the business would expect might not be the same thing. So one thing that's really vital is that the FTC says as a best practice, or what the FTC expects, is that the disclosure needs to mirror the media. So this comes a lot when you've got a post that's a video or a post that's just a picture. If, in particular, when you have a video where a claim is being made orally, it's being spoken, or if it's being written on the video, the FTC expects that the disclosure is made in the same format, that someone is saying this is an ad. If they're saying, I love this product, they also need to disclose spoken that they're being paid, they received something of value, they're a brand ambassador. The FTC expects that the disclosure is made every time somebody appears on behalf of their brand. So if I'm an ongoing brand ambassador, I can't disclose it in a Facebook post in 2017, and now we're nearing the end of 2018, if you can believe it. So much time has elapsed. People aren't going, people who are just tuning into that brand ambassador's page might not realize that they are a brand ambassador for this company because it's already pushed down to their 2017 posts. The FTC has given some examples of what would be sufficient for a disclosure. I'm a spokesperson. I've teamed up for. These are a couple of examples. We have others, and the FTC has really great guidelines out there. If you're using social media endorsers, you really should look at those. One thing that the FT has said time and time again, and this is a general principle of advertising, and it is that you cannot disclose this just via a hyperlink. Like, you can't just have the endorser have a website with a hyperlink that says about, or, the FTC might even take the position that the word affiliate is not enough to disclose. So it really should be clear and conspicuous. Within the post, the disclosure should mirror the way that the claim is being made. So here's some things that the FTC says about how it should be disclosed. So at the beginning of a longer post, don't make somebody have to click more to read the disclosure. That #ad should be at the beginning of the post. It should grab attention. You shouldn't have a ton of hashtag or @ terms. People shouldn't need to scroll. As I said, it shouldn't be hidden in a hyperlink. Here are a couple of examples, but I'm actually going to move on because we're running low on time and we have a couple of other channels that we wanted to get to. So the next one is native advertising. So that's content that bears a similarity to the surrounding content. It's something that people wouldn't think of when they're looking at it to be an ad. So it might be something that looks like a news story, or it might look like a blog. It might be a product review that's actually a paid placement. So what the FTC really says about native advertising is that consumers don't understand. They can't figure out somehow that this article is advertising because they can't distinguish between something that's paid and not paid. So the FTC expects people to disclose that. just like with the endorsement and social media influencers. So what the FTC says is that you and an advertiser need to disclose that content is an advertisement or it's sponsored. As with all disclosures, it needs to be clear and conspicuous. So it needs to be at the top of the page. It needs to be set off from the surrounding font. It can't be hidden in a hyperlink or an about. People shouldn't need to scroll to the bottom of the page. One question we get a lot is whether or not something is even an advertisement, whether or not product placement is an advertisement. And what we always say is that if you're not sure if it's an advertisement, disclose, because you can't go wrong with disclosing. You can't go wrong with making it clear to consumers that it is an ad. We have clients who are very creative in the way that they disclose, and they make it so that it seems more native, that it's more streamlined. And so the FTC really takes the position that consumers are not sophisticated. Consumers don't understand. So if you're ever in doubt, I would say err on the side of over disclosing.
Last topic is the TCPA, so the telephone and text message marketing. Again, we could do a whole other presentation on this, but it could be summed up as follows. There's a federal statute that regulates outbound pre-recorded telephone calls, auto-dialed telephone calls to cell phones, and text message marketing using an auto-dialer to cell phones. The penalties are astronomical. That's between $500 and $1,500 per message, which if you do one or two drops adds quickly into a very expensive exposure. One way to eliminate that risk is you have to have consent. So you got to have prior express written consent to send these messages. Text messages would be, for this audience, probably the most important thing to take into consideration. And that's absolutely a rule. If you send auto-dialed commercial text messages to somebody's cell phone without prior express consent, you've triggered the statute. And because this is such a severe penalty, and the penalties ramp up quickly, one thing that your organization should consider is whether you just want to ban it outright. Same thing for email marketing, for that matter. I mean, you can have an absolute ban on these things in your contract to make sure that these don't happen. But if you are going to use text messages and you are going to use outbound pre-recorded calls or calls to cell phones which are not pre-recorded, or they are, you've got to have prior express written consent, and we can show you the next slide to give you that penalty. Again, it's up to $1,500 per violation, but the federal regulators can result in $41,000, $484 per violation. So the numbers are astronomical. It's a very serious statute. It's something that really needs to be complied with or avoided altogether because it can put people out of business in the blink of an eye. That also would apply to do not call requirements too. That's on the last slide. We can show you the DNC rules need to be followed in honoring opt-out requests and that sort of thing. So I think we're about out of time. We appreciate everybody's business. Sheen, do you have any closing remarks?
So if you have any questions, you can submit those via the widget, and they'll get sent to us, and we'll respond within a few days to a week. And so please feel free to reach out to us. Our contact information is here as well, and we're really passionate about this stuff. So please feel free to ask us anything. All right. Thank you for joining.